Good afternoon, Chair.
Advocate Nkcukaitobi, we have not finished reading, but we have made progress. We are comfortable to start with your witness. I suppose that the evidence leaders also have had a chance to go.
Find it now. Saying is a response to the minister who has asked.
To be signed or to be sworn in.
So the statements you got specifically from Mr. Danikas,
Yes.
which was not signed,
Yes.
signed only later in 2014.
Yes.
What is the admissibility status of that statement?
In terms of the judgment and in terms of the law, those statements are admissible for the issue authorization of the poker racketeering certificate.
Yes, I understand. Now, then there is another judgment, which again we need to go to because it has not been referenced by the NPA, but it explains the judgment of Judge Govan, J, and which you referred to at paragraph 60 of your statement.
Yes.
Now, this is the judgment of the General Council of the Bar of South Africa versus Jiba and others, which is in the same section, but at CL 00411.
I'm there, Chair.
Now, if you, I don't know if you remember the facts around this case. What had happened is that Advocate Jiba was facing two proceedings. Proceeding number one was a fitness inquiry similar to what you are going through.
Yes.
Proceeding number two was a fit and proper inquiry brought by the GCB in the High Court.
Yes.
This judgment was in respect of the case brought by the GCB in the High Court.
In the High Court, yes.
But it was still the same facts about her affidavit that had been criticized by Judge Govan, and whether that criticism would constitute a basis to say she is not fit for office.
Indeed.
Yes. Now, the judges deal with that extensively, and I want you to go to specifically starting at paragraph 51, which you will find at CL 00421.
I'm there, Chair.
Yes. That is where the judges are explaining what her affidavit is and are trying to show that Judge Govan may have been too quick in some of his conclusions.
Yeah.
What do they say?
From paragraph 44, Chair?
No, 51.
Oh, 51.
Yes, it's CL
Yeah,
0042. Okay, thank you.
Paragraph 51.
51. CL 00421, Madam Chair.
Can I proceed, Chair?
You proceed, sir.
Having regard to what is quoted above, it does not seem the statement. Jiba says that they are all statements made under oath. Is
Just
correct.
wait. Where does that come from? That quoted part. Jiba says that they are all statements under oath.
It's a sine qua non to what is being explained in, above in paragraph 50.
Which comes from?
Which comes from Jiba's answering affidavit.
No. That quotation, it says it's not correct. Right?
Yeah.
Does that not come from the judgment that we looked
No,
at?
that is come from judgment. It's an analysis in respect of the Govan J judgment.
Precisely.
Yes.
Carry on then. So in other words, it's saying the findings made in the Govan J judgment does not appear to be correct.
Yes.
Yes.
Nowhere in Jiba's answering affidavit did she make such a statement. neither did she say any of annexures NJ2, NJ3, NJ4, and NJ5 were under oath.
Yes.
Under
Again,
oath.
to stop there again.
Yes.
Was that one of the findings in the Nkabinde judgment, that she has said that these NJ2, NJ3, NJ4, and NJ5 are under oath?
That's what it seems to have been what Nkabinde would have indicated, that they needed to be under oath.
Yes, well, we can go through it, but look at paragraph 49 of the judgment you are reading now.
Paragraph 49 reads as follows. Before dealing with information placed before JIBA for written authorization in terms of Section 2, subsection 1 of POGA, it is important to reflect whether the invitation by Boysen and the adverse remarks by Nkabinde were based on a correct evaluation and understanding of JIBA's answering affidavit. The challenge or invitation by Boysen to JIBA was contained in the replying affidavit, and at the risk of prolonging this judgment, I repeat the contents thereof in part. That is the quotation. She is invited to explain how she could have taken into account information on oath that objectively did not exist at the time of taking the decision. The invitation was made after having made allegations of mendacity in the same paragraph, with reference to paragraph 21 of JIBA's answering affidavit in the Boysen matter. And because of the relevance thereto, paragraph 16.6, 16.7, and 17 of JIBA's answering affidavit in that case are repeated hereunder.
Yes.
16.1, quote.
16.6.
16.6, quote. The information under oath which was placed before me also indicated that the applicant knew or ought to have known that his subordinates were killing suspects as aforesaid instead of arresting them. 16.7. The information further revealed that unlawful activities of killing the suspects and or civilians were, in certain instances, motivated by the applicants and members of the unit's desires to enrich themselves by means of state monetary awards and or certificates for excellent performance. In this regard, I annexed a copy of an example of such a monetary award claim document as NJ1, in which, inter alia, the appellant is recommended for such an award resulting from the death of suspects. Paragraph 17. Particular reference is made in this request in regard to the statement made by Colonel Rajendra Sarjes, Mr. Aris Danikas, and Mr. Ndlondo, from which it is apparent that the applicant is well aware of the information that the respondents have in their possession relating to the murder of at least 28 people and the monetary and non-monetary awards claimed by him, the applicant, for the instrumental part that he played in these crimes. Additionally, Mr. Danikas has revealed some of the information that he has provided to the respondents and to the press, and even posted video footage thereof on YouTube. I annex copies of this statement as NJ12, NJ13, NJ13, and NJ15 respectively.
Yes. Now, if you just stop there, I mean, you've seen here the judges go back to the underlying pleadings in the case that was before Nkabinde.
Nkabinde, yes.
And they say, look, our job is to evaluate whether the allegations of mendacity that were made in that judgment are supported by the underlying evidence.
Yes.
And then they quote the underlying evidence in extenso.
Indeed.
Then they analyze it from paragraph 51.
Yes.
First thing they say that JIBA never said that all of the statements she relied on were under oath.
Indeed.
And you've seen paragraph 16.6, 16.7, and paragraph 17. Is that consistent with paragraph 51?
No. In fact, it's to the extent that it's explaining JIBA's assertion. It's what the full court is saying is JIBA is consistent in respect of what is being alleged.
Yes. But also specifically, she has never, you remember the criticism in the judgment, of Nkabinde
Yes.
is that you have said that you have relied on information under oath,
Yes.
when in fact you have statements that are unsigned.
Yes.
And the judges here are saying she never said she relied on information under oath. She
Indeed.
said she relied on information.
Information.
Yes.
Yes.
Now, I know this is not a case against Advocate Jiba, but she was condemned wrongfully and ultimately lost her job in the NPA.
That was my view then, and it's still my view now.
Yes. Then it continues there that it says, under oath statements or information was made only in paras 16 and 16.6 of the answering affidavit,
Yes.
without suggesting that all of the annexures referred to in paragraph 17 of the answering affidavit in the poison matter were made under oath. Now, that's why the judges are explaining
Yes.
that there is a difference between where she says, I've relied on statements under oath, and where she says, I've relied on information.
Yes.
And then it continues the final sentence there. Therefore, the statement, the document referred to as a statement by Master Danikas, Annexure NJ3, is not a sworn statement. As stated in paragraph 31 of Govan J's judgment, has to be seen in context insofar as it was understood that Jiba averred that NJ3 was a sworn statement.
Yes.
The truth is, she never said NJ3 was a sworn statement, and it could not reasonably have been so inferred, particularly reading in context paragraph 16.7 of her answering affidavit in the poison case quoted in paragraph 50 above. You see that?
Yes.
Yes. You see, if you remember, when we were in this case, Advocate Patoi repeatedly said Mr. Chauke is complicit in the falsehoods that were told by
Advocate Jiba.
Advocate Jiba.
Yes.
Now, yes, thank you. My junior has pointed this out. In the Advocate Patoi's statement, if you have it in front of you,
Yes.
paragraph 180.8.
Paragraph 18.
180.8, Madam Chair.
180.8.
Yes. Do you have that?
I have that. It's on page 76 of the statement.
Yes.
Yes.
It says there is prima facie evidence that Advocate Chauke was complicit in the fraud and perjury charges leveled against Jiba. You see that? Why that's important is because Advocate Patoi knows about that
Yes.
when she is still accusing you of complicity in a non-charge. So if you go to 377 of your statement,
I'm there, Chair.
yes, what do you say there?
The difficulty with Advocate Pato's allegations compounded by a further material fact which her affidavit does not disclose. The allegations of fraud and perjury against Jiba were in fact referred for prosecutorial consideration. The matter was considered by Advocate Ivy Tenga, the Director of Public Prosecutions for Limpopo, who declined to prosecute.
And it's here, the actual decision is referenced at B02199. So, yes. So go to B02199.
B02
02199, which is,
B.
sorry, I'm also trying to work that out. It's B9.
You said B00
219.
219
199.
2199.
Yes.
I'm there, Chair.
Yes, I just need to find it as well. Yes. So if you are at B02199,
I'm
is
there,
a
Chair.
decision by Advocate Tenga to Advocate Abrahams, dated the 13th of August 2015, S versus Ngcukaitobi, Silverton case 622/10/2014. The case has to be dealt with in terms of Part A, prosecution of certain categories of persons, NPA Policy Directives, Paragraph 6C. I decline to prosecute Advocate Ngcukaitobi in all the charges preferred against her. Reasons for my decision are fully contained in my opinion. Now, the reason I ask you this is because you are now accused in paragraph 180.8 by Advocate Batoi of complicity in an offense that she knows was not prosecuted by Advocate Tenga.
Yes.
How do you explain that?
The desperation with the narrative that should find favor in respect of that I'm guilty of some conduct or that's what is at play, Chair.
And she does so in circumstances where she does not take the panel into confidence and explain that I actually know that in 2015 this was not a prosecute.
Indeed.
Now, we then go back to the underlying analysis by the judgment of Judge Lekhodi. So we've dealt with paragraph 50, 51. Then in 52, he deals specifically with the claim of mendacity.
Yeah, I'm there, Chair. 52 says the fact that
Yes, carry on.
52 says the fact that Jiba did not avail herself of this the invitation to deal with the allegation of being mendacious, meaning not telling the truth, should also be seen in context. The allegations was made in the replying affidavit. This too, Governor J was mindful of. For the purpose of these proceedings, the criticism by Governor J should be seen in the context of what Jiba now has to say in these proceedings. Paragraph 53. When it was discovered that Boysen had raised certain issues in his replying affidavit, the prosecution team felt that it needed to respond thereto. On 14 August 2013, a meeting of the prosecution team was held. Subsequent to the meeting, a memorandum was prepared and forwarded to the defense team led by Hodes SC, in terms of which it was expected that a supplementary affidavit will be filed to explain the criticism against Jiba with regard to the annexures. On August 19, 2013, an email by Advocate Musing of the NPA was sent to Advocate Chauke.
19 August.
Sorry. In 19 August 2013,
Yes.
an email by Advocate Musing of the NPA was sent to Advocate Chauke, Director of Public Prosecutions, Johannesburg, inquiring what progress had been made with regard to the filing of a further affidavit to deal with Boysen's allegations. Subsequently, Jiba was advised by Advocate Musing that counsel had indicated that no further actions were necessary. Paragraph 54.
Yes.
Based on the explanation above, it is clear that Jiba did not ignore the serious allegations of mendacity made by Boysen. By seeking to file a further affidavit to explain the annexures after the replying affidavit was filed is a clear indication that she was mindful of the need to explain and correct any inaccuracies created by Boysen in his replying affidavit. Therefore, the statement, quote, despite this, the invitation by Boysen was not taken up by the NDPP by way of a request or application to deliver a further affidavit. In response to Boysen's assertion of mendacity on a part, there is a defending silence made by Governor J in paragraph 34 of this draft ought to be seen in the context of what is explained in paragraph 53 above. Paragraph 55, similarly, the statement that, quote, regards the inaccuracies, The NDPP, referring to Jiva, is after all an officer of the court. She must be taken to know how important it is to ensure that her affidavit is entirely accurate. Should be seen in the context of what is stated in paragraph 53, but even most importantly, in the context of her explanation now offered in the present proceedings.
Yes, now thank you. Now, that deals fully with the claims of mendacity, which you are now associated with it.
Indeed.
Directly by Advocate Patoi.
Indeed.
When she does not disclose to the panel these findings by the full bench.
Indeed.
Now, then finally, the full bench deals with the question of the case that was presented. You remember that issue was left open by Judge Govan, who said, I don't want to get into it, whether there's a good case or not.
Indeed.
The NPA must decide.
Yes.
And if it wishes to reissue, it can reissue.
Yes.
But on the same facts, another group of judges came to a somewhat different conclusion, which is set out now at paragraph 57.
Yes.
Carry on there, what does it say?
Paragraph 57.
Yes.
At the time Jiba deposed to the answering affidavit in Boysen's matter, the facts and the evidence against Boysen had been presented to her on many occasions, and she was acquainted with the case against Boysen. In her affidavit during proceedings before Govan J, she referred to Annexure NJ5 being the statement of Mr. Ndlondo, and Annexure NJ6 being the statement of Boysen. These annexures apparently did not form part of the papers before Govan J, and Jiba was not aware why that was not done. I revert to the essence of Annexures NJ5 and NJ6 later when dealing with whether Jiba had information implicating Boysen when she issued the authorization on 17 August 2012. NJ3 was the statement of Ari Danikas, which was obtained round about 18 April 2012 by General Mabula, who led the Hawks investigation team against Boysen. The drafted statement of Danikas was handed over to the prosecution team during June 2012 and formed part of the information she considered in authorizing the prosecution of Boysen. Danikas was a police reservist in the Durban Organized Crime Unit in Katomane and was at that time in Greece. He had security concerns and was unwilling to come on his own to South Africa. On or about 11 July 2012, Advocate Maema asked General Mabula to leave the statement unsigned so that the information processes outlined in the mutual legal assistance legislation, that is Section 2 and 3 of the International Cooperation in Criminal Matters Act 75 of 1996, be followed to formalize the statement. Although the witness was willing to have it signed at the South African embassy, the prosecution was confident that the statement would ultimately be signed through the process outlined as contemplated in Act 75 of 1996, but it formed the basis of the briefings to be considered by her in issuing the authorization. However, the process of signing the statement could not be finalized since the incumbent, Mr. Nkabinde, at the time of deposing to the answering affidavit in the present proceedings, had instructed to halt the process. Paragraph 58. Whilst the statement in question did not relate to the specific incident covered in the indictment, it was, however, intended to corroborate the evidence in possession of the prosecution team that Boysen was involved in the various activities giving rise to the charges against him, of similar fact evidence, which is admissible in racketeering prosecutions. Paragraph 59. An explanation.
You can skip that. I need you to go to paragraph 62.
Paragraph 62. As far as the allegation of lack of information implicating Boysen is concerned, an understanding of the applicable legal framework that was placed before JIBA and the core function of the prosecuting authority is necessary The court may hear evidence, including evidence with regard to hearsay, similar facts, or previous convictions related to offenses contemplated in sections 2 of subsection 2 of section 2 of the NPA Act, notwithstanding that such evidence might otherwise be inadmissible, provided that such evidence would not render a trial unfair. This should be seen in the context of the preamble under POCA, which inter alia reads.
You don't need to read that, it's common ground.
Okay.
Paragraph 63.
Paragraph 63. In my view, the provisions of section 2(1)(e) and F referred to in paragraph 44 of this judgment are meant for the criminalization of such activities. The point I am making is this: courts, for the purposes of an exercise of its discretion in terms of section 2, subsection 2, referred to in paragraph 62 of this judgment, may rely on hearsay evidence and information and or documentation collected by the police and presented to it by the prosecution. If that is so, and courts are entitled to have regard to hearsay during trial, so too should the National Director of Public Prosecution, Jiba and Boysen's case, be entitled to rely on hearsay and similar fact evidence for the purpose of authorization as contemplated in subsection 4 of section 2 of POCA. Otherwise, pervasive presence of criminal gangs will continue to rule with impunity and fear in many of our communities, and resultantly pose harm to the well-being of many communities. Paragraph 64. As I said, one needs to be careful not to be understood as upsetting Gov. J's judgment for having reviewed Jiba's decision to prosecute Boysen. That is not an issue before this court. The issue, however, is whether in granting authorization in terms of section 2, subsection 4, Jiba was malafide or had ulterior motive, in which event the requirements of fit and proper person to remain on the role of advocates becomes relevant.
Okay, you can skip those until start at paragraph 66 again.
The essence of the information before Jiba can be summed up as follows. In addition to what's stated in paragraph 56 to 57 and 60 of this judgment, Boysen was the head of the Katomania Organized Crime Unit in South African Police Services. Members of the police in this unit and under his command had allegedly committed crimes of a serious nature, including murders against suspects who were sometimes framed in the commission of offenses. Boysen knew, approved, and ought to have known of the commission of these offenses. As a reward for the members' unlawful activities.
If you just stop there for a moment, you know, this paragraph 66 is a critical summary.
Yes.
It says this is the information that was before Advocate Jiba, in other words, before the NDPP and the prosecutors.
Indeed.
Just repeat what it says about Boysen. It says Boysen what?
Let me just start here. Boysen was the head of the Katomania Organized Crime Unit in the South African Police Services. Members of the police in his unit and under his command had allegedly committed crimes of a serious nature, including murders against suspects who were sometimes framed in the commission of offenses. Boysen knew, approved, and ought to have known of the commission of these offenses. As a reward for members' unlawful activities, Boysen motivated for an incentive of 10,000 for each of the 26 members of the Katomania Crime Unit, including Boysen himself. Boysen was also commended for outstanding services rendered in that he was part of a team who, through their commitment and dedication, arrested several crime and dangerous suspects for the murder of a police officer.
Now, you just stop there. You see, this is the full bench has already made a finding.
Yes.
That the information that you had in front of you
Yes.
showed that Boysen knew, approved, or ought to have known about the commission of the offenses.
Indeed.
That there were a number of offenses committed by this unit when Boysen was at the head. Mr. Boysen was at the head of it.
Indeed.
It couldn't be clearer. Now, you have a scenario here that Advocate Batoy is now asking this panel to reappraise whether there was information or not, because the charge is no evidence.
Indeed.
This is the second time where they are asking the panel to overturn a court.
Indeed.
Can you explain how we found ourselves in this situation? There's a rule of law in this country. The courts are supreme.
The state kept a narrative, Chair.
Okay, so you can't explain it.
That has been being sung, and the NDPP herself was here singing state capture until you had to ask whether Chauke is involved in the state capture, and said, no, there's no evidence to that effect.
Yes. Now, this is how they then concluded in paragraph 67, that given the information we've summarized was in front of you, that shows all of these elements.
Yes.
Somebody is a leader, people are committing crimes, he's motivating for them to be paid, he himself knows or ought to have known about the commission of these offenses. It says, given all of that, we cannot find that your decision is based on an ulterior motive. Now we have you also being charged of the same thing, that you've prosecuted someone without evidence. But a judge has spoken on this.
Indeed.
Yes. Now, we've covered then in your statement.
Proceed to I think you're going for the next topic. No?
Yes, I am.
Okay, thank you. Advocate Chauke, can you just maybe enlighten us about the question of whether you'll remember, in fact, let me rephrase. There's a time when evidence was laid, especially about the judgment of Nkabinde, that in his judgment he had indicated that there are concessions that Advocate Hodes had made.
Yes.
And outside court, this became a dispute because he said there are no concessions that had been made, and the court erred by alleging that he had made concessions. The question I'd like to ask you is whether these corrections that were made by the full bench, do they in some way or the other also touch on the concessions that were, according to the judge, made by Advocate Hodes?
Not in a specific way, Chair, but at the time, and that is the Advocate Lawrence Hodes, as he felt very strongly about that, and even when he made an advice that this judgment should be appealed, because he felt strongly that he did not make any such concession.
Yeah, I understand. That's why I said there was a dispute. I understand that he said there were no concessions that he made. Yeah. And I also understand that there was initially a desire to appeal the case, yeah, but then ultimately a decision was there. But it's not necessary because Judge Govan had not closed the door to the NPA pursuing the matter further. So all I just wanted to know is whether, not necessarily the entire corrections that were made, but whether there are elements in the corrections that were made that also have some relation to the concessions.
Indeed, if one reads the passages that I've just read to you, which indicated about whether there was evidence or not, whether there was evidence of racketeering, that because the concession, as it was said then, was it said that Hodes SC considered that there was no specific evidence with relate to racketeering.
Thank you.
Thank you, Madam. In fact, Mr. Chauke, I think let's actually answer the question directly. The alleged concession was that there was no evidence from the statements implicating Mr. Boysen.
Yes. Yes.
That was the alleged concession.
Yes.
Now, when you understand the concession in those terms, we can go back, because the whole thing is dealt with fully in the statement by Advocate Sean Abrahams.
Yes.
I think it's in bundle 3 of the cross-examination bundle.
Yes.
Now, if you accept that the concession is there is no evidence from the sworn statements, from the statements rather, implicating Major General Boise.
Yes.
Now, the corrections that were made by the full bench, do they address that or not?
They do.
Yes. Now, yes, so we've now covered right up to page 22, so that's been four pages. Then you have a constitutional and legal framework that goes on for 3 pages. And then we don't have to go there. You've already started to deal with your role as the Director of Public Prosecutions.
Yes.
And you addressed the question that the chair had asked, that this was a poker prosecution,
Yes.
which falls under the purview of the national head of the prosecution service. So
Yes.
we can skip that. Then we deal from page 28 with the Cato Minor and the Boysen prosecution. Yes, I mean, maybe you can just, because we've heard so much about this, but just summarize your involvement, how you got involved, etc.
Before he does that, Counsel, going back to the critical paragraph 66 of the full court, we know that Advocate Batoyi did not read the dockets. She said so. Had she read at least the paragraph 66 and other paragraphs that are critical in this judgment, would she have come to the same conclusions to refer the matter to the President?
Objectively, I would say no. But what I know now is she was hell-bent to make the recommendation anyway.
But not only that, had she read the affidavit of Advocate Jiba, who was seized with the powers to authorize the racketeering, she could only do that on the basis of the information in the indictments, in the dockets.
Indeed, not even only Advocate Jiba, even Advocate Sean Abrams.
Had she read those affidavits, which were part of the court papers, wouldn't she have thought otherwise?
Objectively, one would have
I
thought...
know it's unfair to ask you this question.
No, I understand, Chair. Objectively, one would have expected to have reconsidered the position. But remember, as I say, the narrative was out there that this is what is a state capture and all sort of things like that. So my understanding that she was looking for every reason to be able to fit into the narrative.
Yes. I suppose, Mr. Chauke, the question really is, an NDPP acting reasonably, if they had read this, would they have proceeded? I know there's a lot of subjective views about this.
Yeah, that's why I'm saying, Chair, that objectively, one would have expected her to have reconsidered in a position, to have reconsidered the position that she had taken. Yes.
Thank you.
Yes, thank you.
Thank you, Chair.
Yes, so I was saying that when we start at page 28 rather, take into account that for 3 months we've had a lot of evidence about Cato Minor. But what we just need is a narrower issue about your own personal involvement. So you can just take us through that.
As I indicated, in my coordination role, obviously when the...
No, I think what I need is for you to say, look, in 2012, I was phoned by Advocate Jiba. He said there's a big case, please get involved, etc.
Yeah. On the 8th of March 2012, Advocate Jiba called me to say, look, there is a situation, we've got a situation where there is a case in KZN where the suspects are the members of the South African Police Services who have worked closely with the suspects and the prosecutors. And then there is a request that prosecutors from outside the province should be deployed to look into these matters. Can you please arrange to get me the prosecutors from your office who will be deployed to KZN to look into these cases with the members of the DPCI and IPED? I accepted the request and indicated to her that I will do so. And then there was a request that the following day, I think the 9th, that I should put together those prosecution team to meet with her in her office for the briefing. And indeed, the following day, on the 9th of March 2012, as appears from my statement, where I had identified Advocate Raymond Matenjwa, who was a deputy in my office, and Advocate Jabulan Mlochwa, who was a senior state advocate, and Advocate Ntagaza, who was also a senior state advocate in my office. We proceeded to the meeting with Advocate Jiba, where we met with even police, I think Mabula and others. Then there was a discussion. Then Advocate Jiba then indicated that the leader of this prosecution team will be Advocate Mayema, but he has got some commitment. He will join later later after finalizing the issues with his DPP, J.J. Smith.
So that's dealt with at paragraphs 108, 109, and 110 of your statement, page 631.
Yeah, and then in the same breath, she remarked that the prosecution team is too male-dominated. Yeah. We should be in a position to get female advocates there, and that's what.
Who had put this prosecution team together? Yourself?
Yes.
Is that why it was male-dominated?
Probably. In hindsight, I thought traveling to KZN and they say is dangerous and whatever. I didn't want to expose females.
I'm sure you didn't. Yeah. All right, carry on.
So that's when I also nominated Advocate Pumeza Fuchan and Advocate Patience Muleko to form part of the prosecution team. And then the prosecution team now...
So just before you go there, because I want you to explain to the panel what was explained to be your role, because we know the role of Advocate Mayema. Why? Because it was set out in a memorandum. You are there, you are to prosecute, you're going to defend any reviews, you're going to institute any appeals, you're going to defend any appeals, because the terms of reference are there. But you are not part of the prosecution team. Yeah. You are coming in to play a coordinating role. Yeah. And you know the evidence leaders, they repeatedly say there's a section in the Act that talks about coordination, and it gives that role to the DPP of the province. Now, here you are doing this job on behalf of the NDPP.
Yes.
Carry on. Just explain that discussion, how it happened.
So the discussion was that once I was told and I accepted that they said the DPP in KZN and the prosecutors they are working close relationship and that's how they accepted. Then she indicated that my role will be doing the coordinating role and support to the prosecution team in terms of logistics and everything associated with their activities of prosecutions and now that to me included the supervisory of them their activities, which excluded that I cannot make decisions whether or not to prosecute in respect of these cases because they fall under the jurisdiction of the DPP in KZN, and she was not going to issue me with that delegation because it was not necessary. The prosecution team is the one that is going to handle that, but there is a suspicion that probably this being POGA, the decision that is going to ultimately be made, it will be made by her anyway.
Yes.
So I understood that.
Well, I understand the issue of POGA. I suppose at the time there are two considerations. One, there is POGA, which is exclusively national, but there are also all of these other subsidiary offences, which are provincial.
Yeah, that the prosecution team, especially under the leadership of Mayema, will make decisions whether or not to prosecute those cases in KZN. I understood and I was conscious about that. I should not find myself being make decisions which, if they are reviewed and the like, I might not, they're not be sustainable because I did not have been given that specific delegation. Like in most cases, that once a case has to be divided by the DPP is being sent, and then the specific request from the NDPP to say, here is the docket from another division. You are hereby appointed to decide it. That did not happen.
Yes. So to try and explain this role that you are playing, which is coordinating advisory, were you doing this on behalf of Advocate Jiba?
Indeed.
Because the other option could have been for Advocate Jiba to do it herself.
Of course, or to get any other DPP and the like. And if the DPP Mlosha was comfortable that these things of close working relationship with the Katomania team was something that was comfortable, could do that. That's my understanding. Will be it will have been not necessary for me to be roped in to coordinate the activities of the team.
Yes, but I mean, on the assumption of what I've put to you, that she has the option of doing it herself
Yes.
or asking someone else, because
Yes.
this is exclusive jurisdiction.
Yes.
I mean, what would be the impact of that on the office of the NDPP?
Well, at the NDPP, there's no way that she will be in a position to coordinate things in Durban without her having to go to Durban and attend meetings, some of the briefings and all sort of things. And like, and given the nature of the office that you're running the whole of South Africa, you're not only running a specific division, it is untenable. It will not be possible.
The office would just grind to a halt.
Of course.
Now, earlier you said this is actually not unique.
Yeah.
Even Advocate Batoyi,
Yeah.
when she had to deal with this case, she asked someone from a DPP from Western Cape.
Cape and a DPP from Limpopo.
Yes, who said, look, help me with finding out whether to continue this case or withdraw it.
Yeah.
Yes. Now, is there a reason why, and I know it's unfair to ask you because, you know, it's unclear to me what they say you should have done.
I should have refused.
Yes.
That's my understanding is that.
Council has not finished asking the question.
Sorry, Chair.
Yes, because if you look at the I think it's the opinion by Advocate Harley, who says the fact that you've been asked by the NDPP does not exonerate you of your own responsibility and analysis of the law in order to know the scope of your powers.
Indeed.
Now, that's what I need you to respond to. So I'm thankful to the chair for having for having assisted me to get my question out.
As I say, Chair, my understanding of the NPA Act and the powers of the NDPP, I've got a different understanding from what the opinions and Advocate Shamila Batoyi was saying, that it's not incumbent that the NDPP cannot delegate another DPP to do work of a case from another division. I beg to differ, but that probably I should, because I'm a witness, I should leave to the evidence leaders and yourself to.
No, I think the question I'm asking you is this. Bearing in mind that you are dealing with a crime that is within the exclusive preserve of the NDPP.
Yes.
And the NDPP comes to you and they says, Mr. Chauke, I need you to go and coordinate this on my behalf in KZN. I just don't have the time for it.
Yes.
And you must come and report to me on a regular basis what's going on.
Yes.
Yes. Now, is the expectation of you that you should read the Act and say, I'm sorry, Madam NDPP, this is outside of your powers? I suppose that would be a fair expectation.
That's how I understood it. That seemed to be what was being expected of me to have done.
Yes.
Yes.
But that's the point I'm asking, is that what would be the outcome of that exercise on these facts? You would still come to the conclusion that it was lawful.
Yes.
Yes. Thank you. Now, you've addressed here... yes.
Advocate Chauke, I'm actually really trying to understand this issue. Yeah, the NDPP's exclusive powers, especially in relation to the racketeering, issuance of the certificates and institution of the action. Now, there may be other cases where such applies. We say the issue of issuance of the certificate of institution of the action in respect of transgressions of these laws lies with the NDPP. What I'll request you to assist us with is, ordinarily, what is the norm? If the matters, the crime is committed in a particular jurisdiction, and the matters are to be tried even in that jurisdiction, when the NDPP seeks for or identifies the DPP that should deal with that matter, is the NDPP entitled to choose from any of the DPPs, or is the NDPP entitled to appoint the director of public prosecutions of a particular or the affected area?
My understanding is that the DPP of the particular area should take responsibility for those matters.
Right, thank you. And that would also include even motivations for application for the certificates of racketeering.
Yes.
Now, let's talk about this case in particular. We understand the record says you were acting as the coordinator. You were playing that role of the coordinator. And maybe the relevant period is the period where it was Advocate Mlochwa who was the acting then. And then it's Advocate Noku, who was acting at some point and then became the permanent appointee for the position. In her evidence, Advocate Noku says that in or around August 2012, yes, you called her, inviting her to accompany you to the Judge President of KwaZulu-Natal to go and make certain arrangements regarding the bail application. You remember that?
Yes.
Yes. Now, what caught my attention is that she says you invited her to accompany you. And yeah, well, you did then go to the Judge President to see him and make arrangements, but then the Judge President then said he could only attend to the matter, even if it's not exactly that, upon receipt of a letter written on the letterhead of the KwaZulu-Natal Director of Public Prosecutions. Do you know as to why it is that the Judge President made that request?
My understanding is that the authority to indict and appear in the High Court in KZN rests with the DPP of KZN. Now, what has happened is I had to brief Advocate Nogo because she just came in. And then the following day, that's when we had to meet with the Judge President. So I had to brief her to say this is what is happening, so that she's on the loop, and then me going with her to the Judge President.
Now, you'll remember that during questioning of Advocate Noku, I think it was by Advocate Mutsino, so but during the questioning, amongst others, she was asked a question as to whether does she see making arrangements with the Judge President, especially with regard to the bail application, whether Advocate Noku would see that as an exercise of prosecutorial powers or anything else. And she said making that arrangement constitutes, according to her, of course, constitute exercise of prosecutorial powers. And it was left at that. Now you are now here as a witness, and I think it will assist for you to clarify that issue as to whether you agree with Advocate Noku's understanding or you have a different understanding, and if you do, what is your understanding with regards to just exercising that power or undertaking that duty to make arrangements with the Judge President. Thank you.
My understanding is that that prosecutorial power is not a decision-making power. It's an arrangement for the matter to say it's going to be enrolled, and that like it's not a decision whether to prosecute or not. That's how I understand it.
Okay, yeah. So what you are saying, because I've got to understand you, is that, well, it is a prosecutorial power, but it's not a decision-making power.
Yes.
Right, thank you. Another thing that I'd like to ask is about, I'm looking at the time lapse, ne? That Advocate Noku was appointed in or around the 14th of July 2012 to act to succeed Advocate Molocha. Yeah, okay, on the 9th. The record says the 12th. Thank you for the correction. On the 9th. And in her evidence, when she testified, she also said that after or around the time when the meeting was arranged, ne, that is when she became aware of the Katomena matters, and that there were about 23 dockets involved therein. I think that can be found in paragraphs 39 to 40 of her evidence. We'll check that. But do you remember that as you were sitting?
I remember my recollection is that I had to brief her before we met with the Judge President, and that's where she would have got all the background about the cases and what the case is all about.
Well, I think I'll take you, maybe, well, I don't have time to the statement. It doesn't suggest that, but nevertheless, what it suggests is that there was a communication that you did correspondingly and possibly even telephonically to say you'll be coming for that. And she should accompany you there to make arrangements. And then she goes on to say, it is at this time that it came to my attention that the Katomena cases, there were about 23 Katomena cases and so forth. Now, the question that I want to ask is, when a person is to take over from another acting prosecutor, in this case, when she takes over from Advocate Molocha, what is the expectation and what is the practice in the national prosecution's environment? Is there supposed to be a handing over, or a person just, this one that is the end of the term and the other one comes in and starts struggling finding his or her way, or what is the position?
There is a handing over, Chair, and my understanding on record is that Advocate Mlocha did a handing over in respect of this specific matter to briefing Advocate Noko.
And do you know as to whether the post the arrangement with the judge president, as to whether there was then constant communication with Advocate Noko about these matters of the Katomena, because the KZN were involved in the Katomena cases only?
From how I understand it, the prosecution team led by Mahema will be from time to time, if they were to go to KZN, then they will communicate with her. That's how I understood it.
So at the time when you were then told by Attorney Ngasana that you should no longer work on the Katomena cases, Advocate Noko will then continue with the job. At the time, was it or was it not necessary for you to do the handing over, or had it already been done?
No, the handing over between me and Noko happened as at when the coordination, to say I should stop coordinating, because Noko was not necessarily long. She was new in the division, so the predicament that Advocate Mlocha had about the working close relationship with the Katomania people, Noko did not have that same thing. So on the basis of that, we spoke, and then from there, she would communicate with the Advocate Mahema, the team leader.
Okay, thank you.
Yeah.
Thank you.
Thank you.
Thank you, Madam. So where we were, we've dealt with 108, 109, 110, 111. I just wanted to ask you, you are now the supervisor and the coordinator of the prosecution team, and there is a legal issue that the evidence leaders wish to raise. I'm sure they'll raise it with you extensively. You can discuss it with them. Yeah. But factually, when the prosecution team would meet, would you attend? What would happen? Or you'd attend some meetings and not all?
I will attend some meetings, and some meetings I will not attend between them and the prosecution, especially the meetings which were intended to brief the NDPP. I would always be in attendance in those meetings.
Yes, so it's per invitation, or when you've got something to communicate?
When I've got something to communicate, remember they will say, this is where we are, and the NDPP need to be kept in the loop, because this high-profile matter, she needs to, once she's being asked by the authorities, she should be in a position to explain progress, say this is what is happening with this matter.
Yes. Now, all right, thank you. And then, if you turn over the page, there are further meetings that you attend: 3 May 2012, 17 May 2012, 22 May 2012, 24 May 2012, 29 May 2012, 11 June 2012. So clearly May was very busy.
Yes.
Up to June, because this is the period when the indictment was being drafted, because the draft indictment was produced on the 12th of June.
Yes.
Yes. And so how would you describe what was going on in those meetings?
No, I had to coordinate, and for me to be able to understand what the case is all about, so that I'm able from time to time to brief the NDPP.
Yes.
Yes.
Because, you know, the accusation, you've heard it, is that if you look at the number of meetings that Advocate Chauke attended, it contradicts his claim that he was not involved in the prosecution decision-making, he was merely coordinating. That's really the case that is being made. What do you say? It's
relative, Chair. You can't be a coordinator and then you're passive. You sit in terms of logistics and understand what these guys they are going through. And they're like in terms of, as you see, some it's about security, some is about the stakeholder engagement, where they would have these differences with the investigation team or the iPad, and they're like, so I needed to coordinate and do those kind of things.
And you
And
also had to-
in some of the instances, because of the high-profile nature of the cases, I would attend meetings where they will be being briefed by the investigation teams and the like.
Yes, and you would also need to know something about the merits of the case.
Of course, I mean, if you are there, if you are a coordinator, you can't say because I'm a coordinator, I can't listen to say this case is this about and whatever, and this is what we want to do, and this is the evidence and that.
You see, this is where I want to really get your comment on. We have a strange scenario in this case of Advocate Batoyi saying the only thing she ever read about Nkcukaitobi was the report by Advocate Tikok.
Yes.
Only thing she ever read. She's got no other reference point other than that report.
Yes.
Yet she has made so many significant decisions of withdrawing a case and recommending to the DPP of KZN that against Mr. Boysen, the case must be withdrawn. But the only document she has is that instrument. Now, and I put to her that, look, contrary to what you've done, Advocate Chauke actually has read the material from the dockets. So, although he's a coordinator, but he's steeped in the facts. He knows what's going on in the case. Now, that's where I want you to tell us what you actually read coming from these dockets.
There is a list that I prepared. I'm not so sure if copies would have been made to the.
I thought it had been handed up. It has not been.
No,
Right.
not that I'm aware.
No, that's fine. Don't worry. Perhaps, Madam Chair, could I just ask for leave? It's probably a useful index anyway. It's a list of annexures, and then it's documents considered by Advocate Chauke before the review, post the review, and then in relation to the racketeering, and then it's the documents in relation to the Mdluli matter. Do you have it with
Yes.
you? Oh, yes, wonderful, thank you.
So what you would have seen,
So what page are you at?
is page 3 of the document.
Yes, thank you.
The first 2 pages is a list of annexures to the statement, to witness statement.
So, sorry, just wait a second. I think the chair wants to.
Yes, this list of annexures is just to help us to locate where these documents are.
Yes.
You already have them in this bundle,
Yes, they're already there. Yes, they're
just to
already
help
there.
us to locate them.
To locate where they are, yes.
Yes.
And then, Mr. Chauke, you are where now?
No, I was in page 3 where I said the first 2 pages is the index to the annexures which are part of the statement. So the annexures are there in the statement, but they have not been identified
Yes, that's what the chair wanted to understand. But
Yes.
my question here is this. You have a scenario in which someone in the position of the NDPP says to the panel, the only thing I ever read about this was the Tikok panel, and makes sweeping decisions about what should happen in the future of the prosecution. Never says, I never opened the docket, don't know anything that's coming from the docket. And that person also says, Mr. Chauke must be charged because in his role as a coordinator or convener or supervisor, he supported the prosecution without evidence. This is an extremely serious charge made by someone who only read the Tikok report. Now, when you were there at the time, what documents did you yourself personally consider?
That is the one that I'm saying on page 3 on
Yeah.
the index. I've listed them.
Yes.
Chair,
All
I can read them quickly
Yes, please.
on the record.
Yes.
Because I would not even be able to to brief Jiba about this case if all I do is to have documents without reading them.
Yes.
It's monetary awards for both.
Before you proceed,
Yes.
Advocate Chauke, can we give Advocate Jiba her title? She's Advocate Jiba, and the whole day she's been referred to as Jiba.
I'm sorry. My apologies. My sincere apologies. My sincere apologies, Chair. I've listed them under the heading that documents considered by Advocate Chauke in respect of the racketeering charges. The first one is monetary awards for poison and catomania unit,
Yes.
with the reference on the record filed in the record as B00017 to B0034. And then the second one is High Court application by Bongani Mkize, DC 00767 to DC 0095.
Yes, and that includes its annexures, the whole
It
pleading and
annexes
the
the
court
whole
orders.
yeah.
Yes, thank you.
The third one is meeting on 9 March 2012 with the TPCI at NPS head office. Documents considered, email dated 8 March. This is the meeting that, as referred to, I was called on the 8th, and on the 9th there was a meeting at national office. And then the email that I sent to Jiba to adding the prosecution
Okay,
team.
it's Advocate Jiba. Can I? Sorry.
I'm not sure whether it is easy when people have been working together as colleagues for many years. You may proceed, Advocate
I'm very
Chauke.
sorry. I'm very sorry.
You had us last year cautioning Advocate Batoi.
Indeed.
Yes.
Indeed.
So
My apologies.
you can
State,
try. You can try.
statement of Simpiwe Cyprian Matonti,
Yes.
DC 001,000 to DC 001011.
Yes, we looked at that statement
Yeah.
extensively 2 days ago.
2 days ago, that's the one that I referenced.
Yes, all right. Thank you.
Prosecution team briefing of 24 May 2012, documents considered, memorandum dated 23/12/2012, which is on the record as B00459 to B00462. The other one, I accompanied the prosecution team and the investigation team to Melmoth in respect of the Biela matter. This is the matter which was in the front pages of the newspapers.
Yes.
So I went there, accompanied the prosecution team and the investigation team when they went there to see the families and the like. And on the same date, I accompanied the prosecution team and the investigation to Eskaweni in respect of the KwaZulu matter, which was also making high waves about a child who was killed while sleeping with and watching soccer.
Yes, and I mean, the people that have withdrawn these cases have not even been to the families.
I understand so.
Yes.
Okay, Nkcukaitobi,
Yes.
I'm going to request that you pause here.
Yes.
We said that we'll take adjournments after every 1.5 hour.
Indeed.
I think we can take a longer break for some of you who eat dinner before 6 o'clock. You can maybe go and have a snack. I think 30 minutes will be appropriate.
Thank you.
You remember we said you'll work until a little bit late so that you can make good progress. I think it's opportune, Advocate Chauke, to pause for 30 minutes.
Thank you, Chair.
We have asked that they boil water for you to have coffee.
I'm sure we can do that. Would
You
be
are
our
under
supper.
oath, we are adjourned.
Thank you.
Good evening. Good evening, Advocate Chauke.
Good evening, Chair.
Advocate Nkcukaitobi,
Thank you, Madam Chair.
I interrupted you
Yes.
when you were at, you had just dealt with the meetings at 112. I can't remember what else you were dealing with.
Yes, Madam Chair, I was looking at the documents that the witness had regard to.
Oh, yes.
Yes, from the note that was circulated before we adjourned.
Is the documents considered by Advocate Chauke in respect of the racketeering charges?
In respect of racketeering, yes, Madam Chair.
With a view to brief the NDPP
Yes,
or
yes, with the view, yes, to brief the NDPP and to play his coordinating role.
yes, thank you.
Yes. Thank you, Madam Chair. Mr. Chauke, we are at page 4, just before the draft indictment.
Yes.
Now, the draft indictment is produced sometime in June 2012, correct?
Yes.
In fact, I think that it was circulated to you on the 12th of June.
Yes.
Yes. Now, at that point, I mean, what meetings had you already held, and how were you familiar with the case?
Well, I will not remember how many meetings, but I would have attended the meetings where there was a briefing to the acting NDPP. I think 2 meetings, and then I would have attended, as I indicated, the meeting with the prosecution team, even when they had to prepare the briefing that they will do to the NDPP.
Yes, well, according to this, the substantive meetings you attended would be from on the 3rd of May, 17th of May, 22nd of May, 24th of May, 29th of May. That's 5 meetings.
Yes.
Yes. And then we know that the draft indictment was prepared by Advocate Mayema,
And
Advocate Matendra, and the rest of the prosecution team.
Yes.
Yes. So when it was circulated to you, what was the intention?
The intention was for me to also update and apprise the DPP of KZN.
Yes. I mean, did you regard yourself as being able to comment and say, look, my view is that this particular charge should be phrased differently, or?
No, there was not even a necessity for me to comment then.
Yes, but you had to be sufficiently familiar to play your role.
Yes.
Yes. All right, so we know you had that before it was finalized. There was an issue taken, maybe you can help us with this. There was an issue taken with Advocate Mayema about when, well, it was not taken with Advocate Mayema, it was taken with Mr. Mangena about Advocate Mayema, which is at the time at which the reports were prepared by the ballistics, because they appear to be signed in September 2012. But there already was a draft indictment by the 12th of June. And I couldn't work out what the point of the criticism, whether the point of the criticism was that the prosecutors had decided what the case is and they were just looking for evidence to justify it. I mean, what was your sense as a coordinator?
My sense is that there is a misunderstanding that the signing of the ballistics report should precede the indictment, and which is not accurate, because the Mangena and the investigation team were always meeting with the prosecutors, and they would have drafts of what Mangena says this is what is going to happen. Yes. Remember, in most cases, in majority of cases, the ballistic test results, you require them when you say you want to go on trial, you prepare for trial, then you get that. But in terms of preparations and you always have the drafts which have not necessarily been signed.
I see. So the signing in September has nothing to do with when they are actually prepared?
No.
Yes, all right. So that's just a basic misunderstanding of how the criminal process works.
Precisely.
Just one please. Advocate Chauke, would you say that the experts like Mr. Mangena
Yes.
can also be seen as part of the investigation team?
Yes.
Yes, because when you look at the prosecution, normally they guide even the police officer on which way to go and so forth.
Yes.
So he would have been also part of the investigation.
Yes. So if you say in instances where Mr. Mangena and Mr. Stale, they would have sat with the prosecutors and the prosecution team where they were doing the briefings, showing them in respect of this docket, this is the space and whatever. So that does not necessarily mean that he must first go and draft a statement and then come in and say. It doesn't work that way.
Thank you.
Yes, sorry, just can you repeat your answer? The question is, do you regard the experts like Mr. Mangena and Mr. Stale as part of the as part of the investigative team?
Yeah.
The answer is yes.
Yeah.
All right. Thank you. Now, if you turn over then the page to page 5, the small documents there that you had access to and considered.
Yes.
Just take us there.
The statement of Kinkosi Mtiani Ndlondo, this is 00640 to this is 00646. Statement of Colonel Aya, B00926 to B00929, B01266 to B01271.
Yes.
Statement.
Just yes, if you can stop here. You know, there was also another issue taken about the statement of Colonel Aya that was produced on the 31st of August 2012. So the suggestion was, well, how could this statement be taken into account because the indictment was served, the racketeering indictment was served on the 17th of August 2012. You remember that?
Yes.
Yes. And I think it was Mr. Mayema who was challenged with this. And then he says, well, but the information was taken before, although the statement was signed later.
Certainly. You'll see that the other statement is 4 August. The other statement is 31 August.
Yes.
Yeah.
Okay.
But doesn't it happen in a criminal trial or in a criminal case where charges are preferred against someone and the trial commences, yet the investigation continues?
Indeed, Chairperson.
In other words, the investigation never ends.
No.
Until the judge says, this is the pronouncement.
Or until if on the part of the state we say we have closed the case for the state.
Yes, indeed.
Yes.
So you can come up with statements even when the trial has begun,
Yes.
correct?
Yes.
Yes. Does it really stop when the state has closed its case? I thought even when you listen to the version of the other side and there are things to be followed up, you're still entitled to follow those up.
No, I'm talking now in terms of the investigation leading to the trial.
Oh, I see.
At that stage, because that the determination you can only make it after when there is the evidence from the defense, and then that will call for you to respond, and then you'll go and investigate those aspects that you think needs to be. Yeah.
Yes. Okay. And then the statement by Commissioner Brown.
Statement by Commissioner Brown, this same 00945 to this is 00992. This is 00998 to this is 00999. And then statement by the Danikas cross bundle, which is in file 1454 to 472.
Yes. Just tell me, I mean, what was your this statement became a subject of a major controversy, and but you know when the witness finally testified, it's just nothing meaningful was put to him. What was the issue from your understanding at the time about Mr. Danikas?
The signature.
Yes.
Yes. Which was irrelevant in any case, whether the signatures was there or not. But the information about what is it that was being contained in the statement, that's what served before Advocate Jiba.
Yes.
Yes.
But I mean, what was the prosecution team's strategy around this issue?
The strategy, as I understood it then, because they always because of Danikas having raised the issue of security and all sort of things and that. They said they are not going to identify him, that is the witness in the case, because that rendered him susceptible to security threats that he has always been sharing with the prosecution team. That's how I understood.
You know, the odd thing about this complaint that Danikas's identity was not disclosed is that if you look at another witness, Mr. Matonsi,
Yes.
whose statement is referred to at page 4 of your list,
Yes.
item 2,
Yes.
you know, it's common cause he was murdered.
Yes.
Yes. And if you also look at page 5, Mr. Begingos Ndlondlo,
Yes.
whose statement is referred to as the first item, it's also common cause he was murdered.
Yes.
You know, and so it makes one wonder why Major General Boysen was so interested in the inclusion of Mr. Danikas in the list of witnesses, when everyone knows that witnesses were killed.
Yeah, the things, as I understand it, which is natural, is once the prosecutor decides to say this witness set danger, and to identify him to the defense without just saying, giving a statement and redacting his name and address, is precisely for that purpose. And that is the provision which is there in the Criminal Procedure Act.
Yes, yes. And then the next item is the prosecution memorandum.
Which is at B00993 to B01027. And ballistic reports of Captain Mangena is 2A1 to 2A338 of Captain Mangena's statement.
Yes, why have you not included the ballistics of
Mr. Stale.
Mr. Stale?
At the time when I considered the these ones, because this to me the ones that I was submitting when we were doing when we were defending the review application by.
Yes. No, in fact, my junior corrects me that the reports by Mr. Stale were part of the annexures in the Mkiza application.
In the Mkiza application, yeah.
Yes, yes. So which actually covers what I was asking you about. Yes. Now, these documents, I mean, they are obviously taken from various parts of the dockets, but they are the key. Are they the key in racketeering?
That's what I'm indicating. That's why even the name there on top, I'm naming them as such. That the heading, the document considered by Advocate Chowk in respect of the racketeering charges.
Yes, yes. And
because this is where when we had to defend the review application for certificates to be set aside.
Yes. Now, I mean, understand there are two stages to it. The one is at the time a decision is taken to indict.
Yeah.
So that's all of the things you were looking at in May and in June, where there's a draft indictment right up to the 17th.
No.
Then the indictment is then prepared and served. Right. Now, when was the review brought by Major General Boysen?
You can just help me with the data. I
Yes.
just don't necessarily have the data.
I think it was brought the following year in April 2013. I think we will find it now.
Is it not May 2013?
It could be, Madam Ramakaka.
So somewhere during the start of the year 2013, thereabout.
turns out my memory isn't that bad. 13th April 2013. So,
Thank you, Chair.
yes. I apologize, man, on the Olympics of memory. Yes, so it's brought in April 2013, but I understood that prior to this being brought, there was in fact a request for further particulars.
Yes.
Can you remember that?
It was when the case was transferred from the regional court that was going to be transferred to the High Court.
Yes.
I think when it made appearance there, they filed the request for further particulars, which the prosecution team was responding to the defense and back and forth. And then after the prosecution team, as I understand it, had submitted the further particulars, that's when the accused through Mr. Boys and lodged the review application.
Yes, and the response Mr. Maema spoke about, and I think the document we have it somewhere is about 200 pages long.
Yes.
All of the further
The
particulars.
way he was
that
dealing with the further particulars that were filed.
And then the review was then brought.
Yes.
Now, you remember that one of the issues that are taken, we've now covered what you were looking at prior to the institution until August 2012. Then the review is brought in April 2013. You have to assemble together and defend it. Now, the charges against you here, or the issues to be investigated as per the terms of reference, also criticize you for the role you played in defending the review application.
Yes.
How do you defend yourself there?
The acting NDPP, they had taken a decision that the application for review, even on the advice of the prosecution team, who felt strongly that there was a case. That's what happened.
Yes.
That the defense of that review would never been undertaken if the acting NDPP then would have decided otherwise.
Yes. So the decision to oppose was taken by the acting NDPP.
Yes.
Yes. Well, you know that we looked at the Advocate Maema's delegation of authority,
Yes.
which entrusts him with the authority to oppose not only reviews but appeals,
Yeah.
and also institute
Yes.
reviews and appeals.
Yes.
You know, so he had authority to do it.
Yeah. Well, the application, the notice of motion was against the NDPP.
Yes.
So even if Maema had the delegation to oppose, obviously it would have been with the concurrence of the respondent, who was the NDPP.
Yes. Anyway, your point is that the decision is taken not by you but by the NDPP.
Yes.
Yes. And then what role are you assigned there?
As the coordination, she has to prepare affidavit. She has to file the opposing affidavit, and I got into that, and I advised liaison with Lawrence Odes with all the documents as I listed them here. That which I had to consider, got them from the prosecution team, gave them to advocates Lawrence Odes SC and Advocate Manaka. They drafted, they shared the draft. I shared the draft with the NDPP, corrections here and there, and then take it back and forth and said it. I settled it on her behalf and then sent it to her, and then she signed.
Yes. I mean, it comes back to the point I asked earlier. I mean, what exactly is Advocate Batoyi expecting would happen? There is a big case launched, and it's against the NDPP. But there are many cases against the NPA. So she has to rationalize her time. So it's either she attends to this case individually, or she assigns a person that she trusts to look after it. In this case, she asks you.
Indeed.
And what are you expected to do? Just say no.
The expectation with the narrative, as I understood it, it looks like as if when Advocate Chiva in the capacity of NT, would have delegated people. Those was seen to be state capture and whatever. But when the others would do exactly the same thing to delegate, is very normal, including herself, Advocate Shamila Batu.
So, so what attaches to this criticism is this notion that, well, the affidavit contained falsehood, mendacity, etc., and you are part and parcel of that. We've looked at that. We've shown that actually the foundation to this entire thing was a flawed foundation.
Indeed.
Yes. Now, before the review, there were certain other, I would say, incidental decisions that you were involved in. Now, there are two that I'm interested in. The one is the centralization. You remember the whole issue that, why is Advocate Chauke signing centralization? And now the reason why centralization became important here is because these Nkcukaitobi police followed a man of one of the Ndimande brothers to Rustenburg, and they killed him in his flat. And the question had to be made by the DPP of Northwest, Mr. Smith, to prosecute or not to prosecute. He issued a nolle prosequi, after which it was it rescinded, that nolle prosequi. But then there was a request that all of these must go to KZN, which is where we see your signature there. But can you just explain yourself there?
No, inadvertently, as it were, I should not have signed the application for centralization to Johannesburg using the letterhead of Johannesburg, because that was supposed to be done in the name and direction of the DPP KZN. And once that a mistake was realized, that was where you're talking about recession and whatever, to correct what was supposed to be wrong. And I accepted that one made an omission there, and it was not supposed to be made by me, because those that were in respect of my jurisdiction, the one which was in Don Park and Jimmy Stan and they were still not added there, and I was not going to have to consent to them, because I was going to consent in respect of those, for them to be centralized in KZN as well.
Yes, no, but can you give just a narrative of what actually happened? So this whole thing happens after the 17th of August 2012.
Yeah. So Advocate Mayema has prepared this draft request, and then he asked me to sign them. Now, when I signed them, I think Advocate Musing or Advocate Smith picked up that the letterhead it's coming from Johannesburg, not necessarily from KZN.
Yeah.
And that's how Advocate Mayema went back to correct that.
Yes. The reason for that is because at the time, Advocate Mayema, according to him, is working in your office.
I was sitting in
given them space.
Yeah.
And then what they do is they use your letterhead to type.
To send out correspondences and that, which in this instance of centralization, they couldn't, because in terms of submitting a memorandum or something that the NDPP wanted, it was no issue. I could send it under my letterhead, because it was of no consequence. Yes. But this one, which in terms of statute and and jurisdiction, it had to be done under the letterhead of the DPP KZN.
Now, there was some issue raised with the advocate. Yes.
Get there. I'm sorry to do this once you've begun to ask your question. But I just want to clarify, Advocate Chauke, on this issue of centralization. You are speaking about two documents, the one that had been drawn on the letterhead of Gauteng South, and then the subsequent one that was then drawn from the KZN. What you should inform us about is as to on which application of the two, on which application did the NDPP act? Of which one?
I think she acted on the strength of the corrected one. Yes.
Thank you.
Yes. Thank you very much. So there was an issue raised by the evidence leaders around what is the significance of the signature appearing in a document? Are you taking ownership of it? Are you not taking ownership of it, etc.? That was asked in relation to Mr. Mayema, who says, listen, I drafted the document, but I have no access to the NDPP. The person who has access to the NDPP is Mr. Chauke, and so I'm drafting it in his name, and I'm expecting it to send it on my behalf. And then they look at the memorandum, they say, well, the memorandum doesn't say it is being sent on behalf of Mr. Mayema by Mr. Chauke. So I just want you to take us through how actually you worked with this prosecution team.
Look, let me give you an example. They prepared a presentation, and the presentation must be sent to the NDPP in a meeting that will have arranged, as I indicated. They will give me that presentation. I will send it they will type a letter under my letterhead, and then I'll send the presentation to the NDPP. All right. Now, in terms of the decisions, as it were, once they would have made that decision, the natural thing is suppose that if it's a recommendation about the decision to prosecute, the letterhead that was supposed to be used, the letterhead of the DPP KZN. And which you would have noticed when Mayema testified that he asked me to PP for advocate Nok. So that is the difference. But in most of the presentations that the meetings that I refer to here, all those presentations I sent them from my office letterhead, because it had nothing to do with that you are recommending a prosecution or not. It was information that had to be conveyed to the NDPP. Yes. Yeah.
I mean, I suppose there was an element of trust as well, that no one will abuse a letterhead of the DPP South Gauteng.
No, of course. These are assistant prosecutors, especially Mayema. Maybe I had this advantage that when I was a senior state advocate in the DPP's office, we were together, the senior state advocates in that office.
Yes. Yeah. So when he puts something in front of you and he says, Mr. Chauke, we've decided as the prosecution team to send this to Advocate Jiba. Yeah. It's not like you sit down and you say, no, I'm questioning you. You sign it, you trust them.
No, really. As colleagues, you start from the question of tapping each other. You can't second guess each other. Yes. If we were to do that, the work strains is going to suffer.
And similarly, when this error was made, it's not as if it's an error that is picked up by a stranger. It's picked up inside the team, and it's internally corrected.
Precisely.
Yes.
And that error, the decision maker did not take issue about it. She understood then that there was error. The NDPP who replaced them, Mr. Ngasana, did not think you have to make a meal out of it. Equally, the advocate Sean Abrahams did not take issue about it either.
Yes. I mean, I think that there's a difference in somebody picking up later that you made a mistake and you picking up that you've made a mistake and then correcting it on your own.
Yes.
You know, because it's all showing that everyone is acting in good faith.
Of course.
Yes.
Bearing in mind that all these issues we are talking about, insofar as the Katumena matter is concerned, we are dealing with the poker racketeering provisions.
Indeed, Chair.
Even if you signed and you didn't pick up the error, why then does it seem to be an elevation of form over substance? Am I right in thinking that way?
Indeed. That's why I'm trying to explain, to say, look, there were 3 NDPPs, and then 10 years later on, another NDPP says, no, look, this is something. It's done with malice. It's done with all sort of things, and which is just unfortunate.
Because what troubles me, Advocate Chauke, is that this case has become such a big case, and yet the terms of reference should be guiding us. You explain in your affidavit from paragraph 6, and you deal with this critical aspect of the terms of reference, a decision.
Yes.
If we find, and I need to be held there, if we find that the terms of reference, insofar as the Kato matter is concerned, paragraph 3, the entire of paragraph 3, none of those things referred to, the supporting, the recommendation allegedly made by you, the defending of the review application, the appealing against the decision of Governor J, and any attempt to reinstate those charges. If we find that those things, given the fact that these are racketeering issues within the context of poker, doesn't this fall on the wayside?
Indeed, Chair.
If we find that these things don't constitute a decision, a prosecutorial decision, because neither you nor Advocate Maema or his team could make such decisions, but only the NDPP. So if you find that these alleged conduct on your part do not constitute a decision, what then remains?
What remains there is that there is no basis for the charges as they stood, or the allegations as they stand now.
Because the case has proceeded on the premise, as I understand it, that there was no decision, and I stand to be corrected, Advocate Nkcukaitobi. But then your case went further to gather evidential material to prove that, in fact, there was evidence that justified the institution of the racketeering charges. Is my understanding correct?
Indeed, Chair. My understanding, your understanding is exactly as I understand it, that if there is indeed evidence that there is a case that has been committed, that should be the end of the matter.
So the point is, there is no decision that you have taken, according to you.
Yes.
And if there is no decision, do we even consider the evidential material?
No. To the extent that I accept and I know that I supported the decision, as it were, in terms of me having to send the documents and then prepare these documents to Advocate Jiba and whatever I'm saying, still that that does not make me a decision maker.
Yes,
Yeah.
that's what I'm trying to probe with you. But I'm saying, once you have crossed that hurdle, the first hurdle of determining whether these things that the terms of reference speak about do not constitute a prosecutorial decision in the context of racketeering charges in terms of poker, then what remains of these claims against you?
They have got no merit, and that's why as advised that one had to make that point in the opening statement, that you're charging a person who did not make any decision.
What then remains is, even if we assume in the favor of the NPA that you participated in a prosecutorial decision,
Yes.
that is, having crossed that first hurdle, the allegation that there was no evidence is flawed.
It's fraud.
Because-
It is without merit.
Yes, because what we have been about was to gather information that says, here is the evidence that justified the institution of the racketeering charges.
Yes.
Is my understanding correct?
That's very correct, Chair.
Advocate Nkcukaitobi, are you helping me to understand
Yes.
how?
Yes.
Because this has been,
No.
I thought that we have so much in front of us, and I'm not sure what we are now pursuing. I thought that we should really focus on the terms of reference.
Yes, no, Madam Chair, you are correct. There's just one issue that Junior wanted to bring to my attention, which to conclude that part about the centralization. B? At B5.
Is it in the list that you have just submitted to us?
No, apparently not, Madam Chair.
Should it be included? Should it be included?
Yes, I think we should include it
Before post-review period?
before the, yes, it's 27th August. Yes, it would be before the review period, yes. Space should find it here. It's B01254.
I have it, Chair. It's the one that is addressed to from Advocate Musing to Advocate Jiba.
Yes, no, yes, it's relevant in the context of the answer you gave, which was the actual decision maker, who was Advocate Jiba,
Yes.
is the person who was deciding on centralization. What was going on between the DPPs was which route, it should take. Not that the DPP will decide, but which channel will be followed. Is it the channel of Johannesburg or the channel of KZN?
Yeah. The issue there being that the issue that is being taken there is a consent of the DPP of its jurisdiction is required.
Yes.
So if I'm not the DPP of KZN, I can't issue a consent in respect of.
Yes.
Yeah. So if the offences were committed in Johannesburg and they needed to be tried in KZN, I needed to issue my consent, which must go to the NDPP for the NDPP to issue the centralization.
Yes.
So that is what is being made. That I can't sign a consent to say I consent as the DPP of KZN that the offence committed in KZN should be done in Northwest and vice versa.
Yes, but the point you're making, though, is a slightly different one, which is the decision maker didn't make an issue of the error that had been committed in the previous document.
That exactly.
Yes,
That's
and this is what is here.
Yes.
That's where he says, Advocate Musing says, a directive in respect of the above-mentioned provisions have already been approved and signed by you in the above matter in respect of the offences committed within the area of jurisdiction of the DPP Northwest. However, the application was erroneously submitted under cover of a letter from the DPP South Gauteng instead of DPP KZN. A new request has now been submitted under cover of the attached letter from the DPP KZN dated 20 August 2012. It is requested that the acting NDPP issue a new centralization directive as per the attached draft.
Yes.
It is notable that the concern from Advocate Smith SC is directed to the DPP KZN. The facts are otherwise unchanged.
Indeed.
So when you picked up the error internally and you asked the decision maker, here it is, no one said, Mr. Chauke, go to a disciplinary hearing over this.
Yeah.
It's now coming now here that you should be disciplined over this.
Yeah, that's why I'm saying that other than that Advocate Jiba would have accepted that correction. The others who followed as well did not think that there is anything untoward about that.
All right. Can I ask you? Sorry, finish.
But sitting where I'm sitting now, and the narrative, like indicated, you would have seen once we come into some, when we go some of the opinions, you see there's a specific opinion that is a source of this set capture things, other than the other opinions. And then again, that's where lies the problem.
Well, I mean, there is one opinion that talks about state capture. It's
Yes.
from Advocate Halley.
Indeed.
Yes. But state capture has become irrelevant, Mr. Chauke, because I asked the NDPP, do you have evidence of state capture? She said no. So let's forget about state capture. It's irrelevant.
I understand,
Yes.
Chair, but unfortunately, I'm sitting here because of state capture.
No, but it's irrelevant. There's no point in you repeating state capture. Because the person who brought the charges, I confronted her, she said no evidence of state capture. So whatever opinions from Mr. Halley are irrelevant.
I take the point.
Yes,
I take the
okay.
concept.
Okay, so no state capture again.
Thank you.
Thank you.
My
very much.
apologies.
Thank you, Advocate.
My apologies.
Advocate Ngcukaitobi, thank you. I've been resisting the temptation to raise this issue. In every sentence that comes, I say, I hope I'm not going to hear it.
Sorry, Chair.
You have
I accept.
understood it,
I
right?
understood.
Thank you.
I take the point.
Yes, all right. Now, can I ask you to take your terms of reference again? Let's just do this exercise.
Now that you're going there, where I read and really concerned about council, now that you're going there, there's a catch. The catch-hold clause there in 3.1. I don't know what you understand that to mean. 3.1 of the terms of reference. Then I'm sure council will take you through that so that you can help me. We dealt with this aspect when Advocate Batoi testified, but was left no wiser. So perhaps we will understand better from you, and further witnesses will come and testify. What did you understand 3.1 to mean?
So if you have, is it easier to get a hard copy? Or
Yes, I actually had it. I don't know. I just misplaced it. I came with 3.1, Chair.
You
Okay,
can-
there's
There
this
is
You can look at that hard copy from our researcher.
All right. So it's on page 3 of the terms of reference, and the sentence starts with the fitness of Advocate Chauke to hold office as a prosecutor in the prosecutorial services, in particular in the capacity as a director of public prosecutions, insofar as it relates, 3.1, his direct or indirect conduct of Advocate Chauke relating to his fitness and propriety to hold office based on information, including but not limited to matters related to the following allegations.
That the conduct, whether I did it directly or indirectly in supporting or otherwise recommending the issuing of the racketeering certificates.
Can I ask you a different question?
Yeah.
What is direct conduct as far as you understand it?
Direct conduct, maybe let me put it this way, that I say physically that here is my view, my recommendation that this should happen.
The other one is that which it will be inferred to say, in fact, he did not do it directly. It was done. He used someone to convey this particular message. I'm trying to simplify it in that sense.
But that is also still direct conduct.
Yeah.
Both of those are direct conduct.
I try to make sense and understand what is being conveyed.
And then what is indirect conduct?
I really find it difficult to explain what indirect conduct is, except that, as I say, you would let's take the facts of Katomania in respect of Mr. Boysen, that says he's not on the scene, but is able to drive and direct what should be happening at the scene.
No, but that's still direct conduct. He's giving the instructions.
In that sense,
I mean, the law
unless
usually
if
makes
it's intended to convey an insinuation of malafide.
No, but it's conduct. It's not motive.
No.
Now, because the law usually recognizes either conduct or an omission, but conduct is conduct. And omission is where there is no conduct, but you should have acted, but you failed to act, and that's where you've omitted.
Yeah.
And there's liability attaching to conduct and liability attaching to omission, where there is a legal duty to act and you fail to act. What is unclear in law is what can indirect conduct be?
I read my understanding there was that this the direct and indirect will amount to one and the same thing, but I'm trying to understand and describe it positively as opposed to negatively.
No, but what is the positive description?
That the direct and indirect means one and the same thing.
Yes, all right. But I mean, your statement says these charges are vague and embarrassing.
Indeed, that's what I was trying to indicate in my
And
my
the
opening.
embarrassing part simply means you don't understand what they mean, and therefore you cannot respond to them.
Indeed.
Yes.
So you understand the difference now?
No, I understand the difference. That's why, Chair, I was indicating that to me it would have been one and the same thing, but absent any explanation and, about that, I accept that, and on the advice which I accept. That,
You align yourself with
Yeah.
that. Yes, thank you.
Yes.
All right. Thank you. And then based on information, and then there's another ambiguity, which is including but not limited. Do you understand what that means? Because if you're going to go to a hearing, you need to know the scope of what is alleged against you. Where does it start? Where does it stop? Now, a phrase like including but not limited seems to imply unlimited liability in time and in scope.
That if I'm sitting here and somebody out there thinks that I must go and say something about Chauke did 15 years or 20 years ago, it should come into this forum. That's I don't say mischief. That's how I see that this is coined to be able to open the wider net. What in criminal prosecution say we throw the book at the accused.
Yes. And does that explain why throughout up until now we still don't know the full scope? Because sometimes you've signed a prosecution, you force someone to sign a prosecution memoranda. Sometimes you force someone to sign a docket. And then sometimes the problem is the centralization. You just never know because these charges are a moving target.
Yeah. At times, the description of when you say you're arranging with the JP, which court, that's a prosecutorial decision.
Yes.
You're deciding to prosecute when you arrange a court.
Yes. And then they keep questioning you about exceeding your jurisdiction, but it's not in the charges.
Yeah.
because they've done this unlimited scope.
You will understand, as I understood it, that's why there was an attempt to say that the terms of reference must be amended to be in line with what is now being presented.
Well, after cross-examination.
Precisely.
Which is very convenient.
Yeah.
Yes.
Well, if you look at, we dealt with this during the evidence in chief of Advocate Batoyi, because we really wanted to understand what this part of the terms of reference means. I'm looking at the transcript here, where Advocate Batoyi said the following, and you may comment if you wish. Real decision, whether to prosecute or not. My evidence will include the fact that a prosecutorial decision is not one that is limited to whether to prosecute or not. Your comment?
Precisely, that's the point that I was trying to make, that it's opening a wider net so that if you can't get this, you should be in a position to rely on this, because it's in here. And that's why there is an issue of jurisdiction, when in fact that it's not even an issue. But you, as I understood it, the first 5 days or 6 days of the testimony was about jurisdiction.
Yes, but the point is that this answer does not seem to address the fact that we are dealing with racketeering charges here.
Indeed.
It seems to be answering just a general question in a criminal case.
Yeah.
Am I correct?
You are indeed correct.
Further, we referred to Advocate Mlocha's point in his affidavit that he did not want to sign the indictment because he had not been provided with the memo and the dockets.
Yes.
And Advocate Batoyi says, precisely, Chairperson. Then I asked, yes, but that begs the question, does that impact on the terms of reference in relation to Advocate Chauke's direct or indirect, alleged indirect conduct? And she answers, Chairperson, if you go to the terms of reference, this aspect of the evidence will relate specifically to, and then let me, if I may explain something. I know I have been asked to keep it short, and I really do, but I want to try to help. I want the panel to understand the circumstances. So these terms of reference were drawn up. It appears that it was taken primarily from my letter that I sent to the President recommending an inquiry to be held. The terms of reference were not discussed with the NPA, but it was taken from there. So we still don't get an answer as to what this part of the terms of reference really means. And when you go back to the question of a decision, prosecutorial decision, I still battle to understand what this aspect covers. And it seems just to be a wide clause, and we have not been presented with evidence, at least so far, that seems to support this allegation under the POCA provisions.
Indeed, it's unfortunate, Chair, that that's what it is. But if one looks at how we understood the process that led to the drafting of this, it's confirmed on record that it was drafted after the opinion which was making reference to. I'm no longer going to use that word. In that opinion, there's confirmation that on this terms of reference were settled by Advocate Hali on behalf of the NPA.
Yes.
So my understanding was to try and widen the net, that if we don't get you here, we must get you here.
Yes, I see Advocate Nkcukaitobi tried also to assist there. Can I also assist you? The charge itself limits the factual basis to the finalization of the answering affidavit. It does not include any other thing. Advocate Batoyi, if I may on that point say that I don't know what you say, the chapter on these charges, if you want to call them charges, for want of a better word, states as 3.1 that I've referred to, his direct or indirect conduct should be direct or indirect conduct of Advocate Chauke relating to his fitness and propriety to hold office based on information, including but not limited to the matters related to the following allegations. And my point is that in as much as this attempt to set out or do set out conduct of Advocate Chauke in this context, it is not limited to this. So I still don't know what this part of the terms of reference means, and because we have to make an assessment based on this aspect of the charge as well. And probably the evidence leaders will assist us when they call any other witnesses, if there is evidence to support these very allegations in the terms of reference. Anything else that follows under 3.1, those specific aspects have been addressed. But it is this kind of a catch-all clause in 3.1 that I struggled with. Hence the questions to Advocate Batoyi, but I still find it difficult to understand. Advocate Nkcukaitobi, maybe you would understand it better.
Yes, well, Madam Chair.
Not.
All I can say, Chair, is that I understand, and I look forward to the evidence leaders taking issue with me about that.
Yes, Counsel, is your understanding maybe better than my understanding?
Let me just go to, I think it's day 14. Yes. Page? At page 48. Where does it start? The first question.
The 8th of December 2025.
Yes, Madam Chair. Yes, at day 14. So if we go to at the bottom of that page, so it's line 20. Yes. So I asked Advocate Batoyi, well, this is what I'm debating with you, Advocate Batoyi. What is the indirect conduct that is referenced? So that was the question. She then says, so I need to think about all of the evidence that I have provided thus far. So I then continue. But I'm asking you, I'm putting to you that the charge 3.1.1.3, you are saying the answer to me, no, look at the indirect evidence. And I'm asking you, what is the indirect evidence? She then says, with all due respect, I did not say look at the indirect evidence. What I said is that I was reading out the chapeau, that's like the introduction. And I said it states including but not limited to matters relating to the following allegations. My point being not about indirect conduct, but about the fact that the allegations are not limited to what is set out in 3.11 until 3.115. That was the point. Then I say, now, what are the other allegations that are not included? What do we not have? Then she says, well, for example, the allegations relating to the signing of the Advocate Chauke's request for Advocate Mlotshwa to sign the indictment. I said, no, please. Then she says, that should have been included here. I said, please, Advocate Batoi, we are at 3.1.13. At the stage at which Major General Boyson is in court, the NDPP is filing an answering affidavit. The charge tells us that its scope is the finalization of the answering affidavit. You are resisting my submission to you that the scope is limited. You are saying it is unlimited. I'm asking you, what are the other facts that support the defense of that review application? And then she says, I do not know if there are any other facts. That's why. So where we ended the discussion is when she said she just didn't know herself. So I don't think anyone will ever know. And because the first witness of the evidence leaders is Major General Boyson, I don't think she'll educate us more about the terms of reference.
May I just come in here? Advocate Chauke, when much as at the end they have that, a catch-all phrase where it's clear that the list is not closed. But if we are to focus on the reason for Advocate Mlotshwa refused to sign the letter in the absence of only two or either of the two, and that is either the prosecution memorandum or the original case dockets. So as far as that requirement of the signing or the reasons for not signing, we have a clear enclosed answer. It's not an open-ended answer that we get. Are we in agreement about this?
Yes.
Right, thank you. Thanks.
Thank you. If we then proceed from there, 3.1.1 talks about the institution of the racketeering charges in terms of Section 2, Section 4 of POCA against Major General Boyson and members of the Nkcukaitobi unit and the defense of those actions in subsequent review proceedings brought by Major General Boyson to have the racketeering certificates set aside. Now, the institution of the racketeering charges, whose decision is that?
It's the NDPP.
Now, and then the defense of those actions, I presume this means the review in court. Whose decision was that?
The NDPP.
Yes. Now, then they try and set this out. 3.1.1.1 supported a decision to prosecute the accused, notwithstanding that there was no evidence justifying the decision. And he sought to improperly have the acting director of public prosecutions to sign the case dockets and or prosecution memorandum detailing the alleged evidence implicating the accused on which the decision to indict had to be made. So if we look at the first one, the evidence of Mr. Mayema is that he is the one who recommended the decision. And in fact, he goes further, he says, it's not Advocate Chauke. And you know the interesting thing is that he is never cross-examined on that point. What is your testimony on this supporting a decision?
Like Advocate Mayema indicated, I would, in the coordinating role, be able to understand this is the case all about. But
No, Mr. Chauke, what is your evidence on whether you supported the decision or not in the light of the evidence of Mr. Mayema?
I did not. The person who supported is Advocate Mayema on behalf of with the prosecution team.
Yes. Now, then there is another issue here. You sought improperly to have, that's Mr. Mlotshwa, sign case dockets. Did this happen?
No.
Then there's another thing here that you sought improperly to have Mr. Mlotshwa to sign a prosecution memorandum. Did this happen?
No.
You know, the oddity about this is that Mr. Mlotshwa's email says he never got the prosecution memorandum. Now you have a charge that says you tried to force him to sign it.
Remember, the discussion between me and Mlotshwa is about him signing the indictment, not what is being set out here.
Yes, but I'm saying that he said he didn't have it.
Yes.
The charge is that you said he must sign it.
Yeah.
But how does he sign a document that he doesn't have?
Precisely.
Yes.
Because in terms of that email, is that he was requesting me that I must provide him with a
Yes.
prosecution memorandum.
Then you are being charged for saying he must sign it.
He must sign the prosecution memorandum.
Now, they tried to change this through the evidence of Advocate Batoyi. They said you tried to say he must sign an indictment.
Yes.
But then it fell apart when Advocate Mutsweni withdrew the question.
Yeah.
Yes.
That's when the testimony of Advocate Mayema.
Yes. Now, then 3.1.1.2, you recommended to the then acting National Director of Public Prosecutions, Advocate Jiba, the application for issuing a racketeering authorization in terms of Section 2, subsection 4, whereas there was no evidence justifying the institution of racketeering charges. Now, what's your evidence on this? Again, in the light of what Advocate Mayema said.
The prosecution team recommended the application, and I forwarded that recommendation to the.
You know, the strange thing is that Advocate Mayema said that and then was not cross-examined on this. Yes. Now, then there is this thing about no evidence justifying the institution. I mean, is there any person who is reasonable in their head who can say, after having listened to the 3 months of evidence, that there is no evidence for the justification of the prosecution?
Chair, what I could read from this is that the people, Special Advocate Batoyi and others, they did not necessarily read the actual evidence.
Yes.
They relied on what somebody would have told them, because if they themselves had taken the time to go through the statements or the dockets, even one or two dockets, they would have realized that this assertion is not necessarily stand the scrutiny of justification.
So there's no reasonable person who can say there's no evidence.
No, not at all.
Because we are told that there's Mr. Major General Boyson is coming to give evidence for apparently for 8 days. Now, what is the relevance of a witness who's an accused in a decision, making a prosecution decision?
I'm surprised, and the majority of the NPA prosecutors, most of them, they're asking to say, what is it that the NPA goes out of its way to defend an accused person?
Yes.
It's really the prosecutors. Most of the people who understand what we do as prosecutors, they are surprised. What?
Yes, but isn't it something beyond that? It is the NPA relies on its case on a person who is an accused, who was an accused.
Precisely. As if he was going to say, you charged me correctly, please prosecute me.
Yes. But if you were to make a decision to charge a person, I don't understand. Would you go and ask them, are you guilty or innocent?
This is what the NDPP has done.
Yes. No, I think we can't develop that. Yes. You see, because that's what I really just struggle to understand, is that if every potential criminal in this country was asked by the NPA, go to an inquiry and say you are not guilty, where would the NPA be?
Worse still, it's how many cases are we charging people, and then they go to court, they get acquitted, or they go to court, they on review, they succeed. Yes. Why have those not been complained of, and then inquiries in respect of those prosecutors or DPPs instituted? Yeah. Well, there is something in this one, there is something more than what it's being presented here.
Yes.
But if that happens, that will have a chilling effect
Indeed.
on the prosecutorial discretion.
Indeed. And the prosecutors, some of them, they're even afraid to make, then you are likely to go through a misconduct. Yes. And it's problematic because that is no longer prosecutors exercising prosecutorial decision without fear, favor, or prejudice.
Yes. Now,
at least here, you have told us, and we are yet to hear further evidence, You've told us that you did not make any prosecutorial decision.
Indeed.
And Advocate Maema, as evidence, corroborates that. Am I correct?
Indeed.
Thank you, Madam Chair. Then,
Just,
yes.
yeah, we're talking about the prosecution and responsibilities and obligations.
Yes.
Now, Advocate Batohi told us that a DPP has a duty to prosecute if there is a prima facie case and if there is no compelling reason for a refusal to prosecute. Now, this duty, is it correct to say that duty also lies with the NDPP?
Precisely. And the scale is even higher than when you refer to an ordinary prosecutor.
Okay. Now, looking at the facts and the evidence that is before this panel thus far, would you say that there is prima facie case on which these cases complained of should have been prosecuted? And I'm asking this in particular with reference to the Poisons case. No.
There is overwhelming prima facie case against General Poison and members of the Katomeni.
Advocate Chauke, you're teaching me something overwhelming prima facie. Okay, if for the purposes of this inquiry, maybe one should adopt that. Now, if there is overwhelming prima facie, or rather, let's drop that overwhelming out of the engagement. If there is prima facie case or prima facie evidence, would it be proper for the NPA, and when I'm talking about the NPA, I'm talking about the entire prosecution,
Yes.
be it at a provincial level or what, would it be proper then not to prosecute the case if there is prima facie case?
No, it's very improper. It's not in the interest of justice. Once you get to a prima facie case, it says you should prosecute unless if evidence when you have made the decision comes to the fore that indicates that your prima facie case is no longer sustainable and the like, and that's why you have to reconsider decisions as and when you proceed.
But in her case, she actually explained that unless there are compelling reasons for refusal to prosecute. And I remember talking about in cases like where maybe the parent has
An
knocked
accident,
out,
where a
and so
parent will
forth.
have run over a child
Exactly.
without when she's reversing
Yeah,
a car.
those are examples that she gave. But in this case that we are now talking about, especially with regard to the Poisons case, are there any compelling reasons that you are aware of that have been advanced for the decision of the NDPP to then withdraw the charges against the General Poisons and co-accused?
I'm not aware of any. In fact, I have not seen, even on record, where General Poison has made written representations to the NDPP for her to consider this matter.
Who bears the onus to show that there are compelling reasons for this position to be taken, a position to withdraw or not to proceed with the matter?
the accused persons through representations.
Thank you, sir. Thank you.
Thank you, Madam Amakaka. Now, so we've dealt with 3.1.1, 3.1.1.2. 3.1.1.3. Now, it's talking about you sought to defend the institution in the review proceedings brought by Major General Boyce. Now, who took the decision to defend the case?
The acting NDPP, Advocate Jiba.
Yes. And then you finalized the answering affidavit of the then acting National Director of Public Prosecution in the poison review proceedings in opposing the review application, notwithstanding that there was no evidence justifying the institution of racketeering charges against the accused. Now, the case here, it seems to be that you defended the decision by assisting the NDPP to prepare an answering affidavit. Can you just explain that?
No, the counsel appointed in the matter is Advocate SC and Advocate Manaka. They prepare the opposition to the application, discuss it, show it to Jiba. Jiba says no, help finalize it with the legal team for us to be able to say this, and I send it to Advocate Jiwa. I say I'm satisfied. This is what is coming from counsel, and it's in accord with what has been presented to you for the decision that you have made, which is now being challenged. And she was happy. She signed the.
You know, the problem is, you see, whenever you see something called misconduct, it's usually deviation from expected standard or expected conduct. What I can't work out here is what were you expected to do? There is a case brought against the NDPP. The person cited nominally is the NDPP. She then says, Mr. Chauke, please assist me to draft the application, to draft the answering affidavit, which you then do with the advocates on the brief. What on earth are they saying you should have done?
It's because it's Jiba. You should not have done it.
No, but I'm saying from your perspective, what were you expected to do? What is the expected conduct when your boss says, help me to draft an answering affidavit?
I must refuse and say, no, I can't do it.
But I mean, is that a sensible thing?
Of course, it's nonsensical, to say the least. There's no justification for that, and I can't. It's a colleague to my supervisor. She's asking for assistance within, which is lawful, and then within my work environment, and like, how do you do that?
Yes.
I can tell you now that even in the past 7 years that Advocate Shamila Bato has been here, she has never finalized the affidavits and all those things by herself without anyone assisting her. It just doesn't work that way.
Yes. And then the only way then to justify this charge is this catch-all, no evidence.
Yeah.
But as soon as you cross that line, that's the end of this charge.
Indeed.
Yes.
Yeah, Advocate. Still on this issue of the council that were appointed to deal with this matter, to oppose the review application. The brief to council, who issued the brief to council? Is it the office of the NDPP or is it the office of the DPP?
No, it will be the office of the NDPP through the state attorney.
And that makes it clear as to who is actually opposing the review application.
Indeed.
Thank you.
Yes. Thank you. And then 3.1.1.4 says you instituted an appeal against the judgment of Judge Govan without the approval of the then National Director of Public Prosecutions, Mr. Nkabinde. We've dealt with the catch-all, no evidence.
Yeah.
I just want to get the facts straight around how this appeal story unfold.
what had happened, it's a decision that the Governor J has made. It's given to the prosecutors to say this is what this is happening. The prosecutors looked at the decision, and then they said, no, look, in view of this, we cannot appeal because we are being told that there is a concession that was made by Mr. Hodes. They sent me that view of them. I take that view, I send it to Mr. Lawrence Hodes to say this is the view of the prosecution team. What is your view? And Lawrence Hodes says, no, look, let's have a meeting with the prosecution team because there is nothing like that I had considered and the like. Now, Advocate Mayema, the lead prosecutor, like he indicated, after the discussions with counsel, it was decided no, an approach must be made for the NDPP to file to appeal this ruling by Governor J. Now, the diocese is running, and I was requested to brief Advocate Dr. Ramaite to say this. We have got this scenario. Can we get the approval from the NDPP for the latter to authorize the filing of the appeal? Of course, it was taking some time that Advocate Ramaite did not come back to me to confirm whether and then the dice was running. And counsel advised to say, look, what we should do is we can file provisionally so that we don't have to do condemnations and all sort of things. And like in the event that the NDPP approves, then we'll proceed. If he withdraws, then he will withdraw. And then indeed, that's what has happened. But unfortunately, Advocate Dr. Ramaite omitted to timelessly brief the NDPP, and it came out in the press, and then Mr. Ngasana saw it in the press that the NDPP NPA is appealing the government judgment. Of course, he became unhappy and not appreciating that this kind of a decision would have been taken without his knowledge or approval. Consequence to that, we were called to a meeting between me, the I think it was Advocate Mayema, and Matenjwa, and the NDPP with his advisors, and Dr. Ramaite. And in that meeting, Dr. Ramaite acknowledged to say, apologized to say, no, look, indeed I was advised that I should brief you timeously with the documents to say this is what should happen in view of the government judgment and the like. Of course, Mr. Ngasana then indicated his unhappiness about that, and then he said he accepts the apology from Dr. Ramaite, but he has decided that there should not be an appeal, and then instructed me that I should inform the state attorney to withdraw the appeal accordingly. And that's exactly what I did. After the meeting, I sent the email to the state attorney to say the NDPP has decided not to appeal, and that the appeal should be withdrawn.
You see, because Mr. Mayema confirmed exactly what you're saying, that yes, actually the decision was that of the prosecution team.
Yeah.
And it had to be filed with some urgency because of the
yes,
time limits.
Yeah.
And then when it was decided not to proceed with it, it was withdrawn.
Yeah.
But more importantly, for your purposes, the person who you would have undermined, quote unquote, by appealing without their consent is Mr. Ngasana.
Yeah.
What was his view about this? Did he think, well, this is now a big misconduct charge, I should now go after
No, you know if needs be, probably, if time allows, he will come and testify, or he will send a statement to indicate that he is even surprised that that has been made to be a charge which relates to him, and this was not even discussed with him.
Yes.
I can say for a fact that he's surprised, even as I'm sitting here, he's surprised that there is that kind of a charge that relates to him, and he has never even been consulted.
Yes. I mean, if he thought there was a misconduct problem, he would have instituted charges back then in 2012.
Indeed.
Through you, does this now suggest that Advocate Ngasana is the appropriate person to can talk about whether it was you in some way or the other constituted misconduct, or your actions constituted misconduct by pursuing the
Appeal.
or instituting the notice of appeal? It was not even pursuing the appeal, but instituting that notice of appeal.
No, indeed, Chair. That's what I'm saying, as a matter of fact, because when he saw this, and when I approached him, then he was surprised, and then he said, "How can the NPA and the DPP do something like this without even consulting me?" As if I am the one who's complaining that this is what Chauke and the prosecutor's team have done.
Yes. And then it's the usual story. No charges. Well, no justification for the charges. And then the last one under Kaitoman is attempted to have racketeering charges against Major General Boyson and members of the Kaitoman unit reinstated by the then National Director of Public Prosecution, Mr. Ngasana. So let's just stop there. What does this mean that you attempted to have these charges reinstated?
Chair, on the record, what has happened after when that meeting that I referred to, where Ngasana issued an instruction to withdraw the appeal, he immediately set up a date to say he wants to have a full briefing of the matter, because he did not have the background and all sort of things, and the like. And the matter, the date was arranged, I think the 20. I'll get the actual date on the statement, but it was, I think, 7 days or 14 days after the date when we met about him withdrawing the appeal. And in that meeting, the prosecution team, Mayema and Matenja, they were doing the presentation. In that meeting, Advocate Nogo was also invited to be present in that meeting. And that's where in that meeting where he said, "Okay, I understand, you guys go and find more, because the judgment does not say we cannot reissue this statement." And he made even reference also to a signed statement of Danikas, and they like to say, once you are ready and have got more, bring the application, I will consider it. I understand that meeting is the one that is said to be an influence for him to consider a reissuing of this of the racketeering. Other than that, where it's coming from, I really do not know. But I can tell you now that Mr. Ngasana is also surprised that there is this allegation that there was an attempt, a subtle attempt, or with a malafide, that he was supposed to issue a racketeering certificate. Which
well,
is
I mean, the actual evidence we have so far, even if you forget about Mr. Ngasana for a moment, is from Mr. Mayema, who says that his view remained throughout the tenure of Mr. Ngasana and the tenure of Mr. Abrams, that these charges should never have been withdrawn, they should be reinstated.
Yes.
And he motivated to Mr. Ngasana to reinstate the charges.
Yes.
And Mr. Ngasana felt that there were certain evidentiary gaps to be filled.
Yeah. But when that motivation was done, the second motivation, I was not there. The meeting that I attended,
yes,
in which Ngasana said, no, from now on, Chauke, because Nogo is not as conflicted as a predecessor, you must now stop being the coordinator. Nogo should.
Yes. And And that
should
was
take
in
over.
April 2014.
Yeah, that one, that was the period of that, the appeal and what have you.
Yes,
So, like Advocate Mahema said, he did this presentation and then he was, they were told to go and find more. They went to go and find more, and then they did the presentation to Mr. Ngasana, but he was still not satisfied. They had all those queries and whatever. So the reality is, Advocate Mahema would have been the one who would have went back to consider that this the case should be re-enrolled and the like.
Yes. Well, I mean,
Just coming in here, that portion of the evidence, it is correct that also Advocate Ngasana,
Yes.
I beg your pardon, attorney
Mr. Ngasana.
Yes, Mr. Ngasana. Mr. Ngasana made it clear at some point that he is conflicted.
Yes.
And that could have been also part of the delay. He's conflicted in respect of the Katomena case
Yeah, he said
because of his relationship.
Yeah, he said to some of whether were the victims of the accused that he would have they would have been his client or something to that effect. But like Advocate Mahema had explained, there was something like that, and then he had indicated ultimately I might have to delegate the issuing the authorization of this to one of my deputies.
Yes, but I'm just saying the reason advanced according to the evidence that is now on record is that he had a relationship, be it business relationship, working relationship, whatever, but the relationship with some of the Katomena officials.
Yeah, some of
unit
the West
officials.
clients, I cannot
That's
remember
right.
whether it was the officers or the victims in
Yeah.
respect of, but
Yeah.
something to that effect.
Okay, thank you.
thank you.
Okay, Nkcukaitobi, I know that you have now exhausted the terms. It's late
Indeed.
in the hour. We are not going to sleep here. I hope I didn't interrupt your
No, this is the right time.
clarification. I think we should pause. Advocate Chauke until tomorrow morning at 9 o'clock.
Thank you, Chair.
And I suppose, Advocate Nkcukaitobi, we will run to finish with the witness tomorrow.
Madam Chair, I think we've done 60% of the job today, so we could even have a short day tomorrow.
Can I rely on that undertaking?
No, I don't rely. No more public undertakings.
Yes, thank you very much. Sorry we kept you until late in the hour, but we've made some progress. Advocate Chauke, you remain under oath and you will continue.